Morning. It's a pleasure to welcome our friends in the tax profession to the third episode of Deborah Chambers 11's seminars, the brainchild of my friend Chris Stone. Today we've got Aparna Nathan, Queen's Counsel, and Rebecca Murray, who are going to be talking about LLPs, the mixed membership partnership rules, and profit attribution. It's our aim, of course, to provide you with CPD from clever people, accompanied by the reassuring sound of your own domestic Nespresso machine. Before we go to it, a brief update on what's happening in the first tier tribunal tax chamber. It seems to be continuing with its headlong rush towards total entropy. It's continuing to extend time limits and to adjourn cases. A further stay direction was issued on the 21st of April by Upper Tribunal Judge Greg Sinfield, the President. That applies to all standard and complex cases, that's to say, all the cases that any of us is interested in. Directions in those cases are now stayed until the 30th of June 2020. It's not quite clear to me what happens on the 1st of July, whether you're then supposed to have the case in apple pie order or whether that's the day to start working. I genuinely don't know. And all hearing windows are extended by 70 days. Our experience of that is that the tax chamber of the FTT is now simply vacating hearings and showing no great inclination to fix remote hearings in their place. To take an example, Chris Stone and I had a case, a 5-day case about employment-related securities fixed for the early part of May. That was just taken out of the list. The hearing was vacated, and although certainly in our view it's eminently suitable for a remote hearing, electronic bundle and everything, the tribunal hasn't fixed it and nothing whatsoever is happening, and we have fears that the same is going to happen to a retread of the round the world scheme in a 10-day case fixed for July. In contrast, the Administrative Court and the Court of Appeal seem to be engaging with the possibilities of remote hearing rather effectively. I looked at the list for the Court of Appeal yesterday. There were 3 or 4 remote hearings listed, and I believe Aparna had the mixed pleasure of a telephone hearing in the Administrative Court before Mrs. Justice Andrews yesterday, so no doubt she'll be able to tell us about that. Before I hand over to them, could I remind you of the 2 miracles of technology that are available to you? There's a chat function which enables you to make remarks either privately to your friends or generally to everybody. But there's also a Q&A function which allows you to put forward a suitably daunting question for consideration by the panel at the end of the seminar. These questions are always daunting. Of course, someone once asked me at the end of a seminar I was doing about employment taxation about a particular named reported case. I was able to answer completely truthfully that I could remember only 2 things about the case. The first was that the judge was Mr. Justice Lightman, and the second was that I was in it. I'm sure our speakers will be able to do at least as well as that. As Chris Tarrant was wont to say, the next voice you hear will be that of Aparna Nathan, who will introduce the topic that she and Rebecca are going to speak on. Thanks very much.
So good morning, everyone. I am going to talk to you about the mixed membership rules. But through the prism of a particular case in which I was involved. In fact, it was the first time that the legislation was litigated. The focus of that was condition Y, so that's going to be the focus of my talk. I will touch very briefly on condition X and mention in passing 850D should you really need to take things up further. Obviously, we can have a chat afterwards, possibly by email after the talk. So what you need to know about Walewski, I think, is set out on the screen that I'm just about to share with you. And this was the group structure, or at least the structure of the arrangements. And you will see that there were two LLPs. That was interesting. One was a main LLP that was client-facing, and the other was a support LLP that provided research and admin back office support to the main LLP. So the main driver for the generation of profits within this structure was the main LLP. And the main driver of that LLP was the appellant, who was was a partner along with a couple of other more junior partners. But he was also the settlor of the NR Trust, you can see over there, of which his children were beneficiaries, but from which he and his wife were excluded, which, as you can see, was an indirect holder of 100% of the share capital of NRCO, which was also a member of the main LLP, but also of the support LLP. Because the facts and the analysis are pretty much the same for support LLP and main LLP, I'm going to focus just on the main LLP for these purposes. So long story short, NRCO had the appellant as a director, had the appellant as its only employee, there was, the point that was being made was that although the appellant was a very large and very important profit generator for the main LLP, the somewhat disproportionate profit share allocation to NRCO was entirely justified by NRCO's own services that it provided through the aegis of its employee, i.e. the appellant. Of course, this wasn't going to pass without some degree of questioning, and as it ended up, the revenue weren't satisfied with the answers given, and the matter was litigated. Now, we all know that the starting point for profit allocation is what is the profit sharing arrangement within the partnership, and that's the profit share that is then allocated to the partner, which then goes into the tax return of that partner or member as the 8(1) capital B figure. However, that amount is subject to reallocation. It may be increased, in fact, if the requirements of section 850 capital C are met. But of course, if 850 capital C is not met, it may be a scenario in which 850 capital D applies. Now, 850 capital D is concerned with where a person who is not a partner is providing services to the LLP, and there is a profit allocation to an NRCO. The question then is, well, should there be a reallocation back to the appellant? 850D is a companion piece to 850C, and can, one might suggest, because it was introduced at about the same time, be seen to, you can look to it to try and understand and construe parts of 850C. Should it be said, well, there ought to be time apportionment? Well, in 850C, well, when you look at 850D, there is absolutely no basis for time apportionment. So it can be used to understand the structure of the package of legislation that was introduced. So that said, I'm now going to move on to the next thing, which is to look at 850C. Now, 850C, and you should have it in front of you, these are the opening provisions. The sub 1 states that if there is a period of account in which there is a profit for a firm, a profit for a partner, and an individual partner, and a profit for a non-individual partner, and condition X or Y are met, then sub 4, for these purposes I'm only going to look at sub 4 applies. And sub 4 is interesting. It provides that A's profit share is increased by so much of B's profit share as it is reasonable to suppose is attributable to, if condition X is satisfied, A's deferred profit, or condition Y is satisfied, A's power to enjoy, as determined on a just and reasonable basis. So there's an apportionment here, but the apportionment is, as you can see, on the basis of attributions to deferred profit and power to enjoy. There isn't a mention of time apportionment, and you will see why that's relevant towards the end of the talk. So the condition X, I'll deal with it very briefly. As you can see, I've set out A's deferred profit definition. What this is looking at is where A is entitled to remuneration or benefits. The question is, it needs to be A's deferred profit. There needs to be some link between what it is said is his remuneration or benefits. Is earmarking enough is a question. So that although it is allocated to A, he doesn't receive it. And then some part of that ends up in B's profit share. The question is condition X satisfied? That is condition X, but we weren't looking at that in relation to Mr. Walewski. We were in fact looking at condition Y. And this is made up of, in effect, 4 conditions, but really 3 are the important ones. Sub A, B's profit share exceeds the appropriate notional profit. Now I'll come to that in a moment. Then that A has the power to enjoy B's profit share, and C, that it is reasonable to suppose that the whole or any part of B's profit share is attributable to A's power to enjoy. So the attribution point you will see is interesting, because if you can show that condition 3A, i.e. B's profit share does not exceed its appropriate notional profit because in fact it earns it, then that amount can't be attributable to A's power to enjoy. So that part will be protected from C1. So let's look at 3A first, which is the concept of appropriate notional profit. Now that is defined in sub 10 as the sum of the appropriate notional return on capital and the appropriate notional consideration for services. Now, return on capital is in effect, it's a time value for money at a commercial rate of interest on the capital contribution to the firm. Short point, if one is going to say that the capital contribution includes ploughing in at A's profit share, then the requirements of section 108 ITA need to be satisfied. It needs to be held as capital. So this is, I would say, the heart of this provision. Because we know that an appropriate notional profit is made up not only of the appropriate notional return on capital, but also on the appropriate notional consideration for services, one needs to know what that means. And what it means is that the amount which B would receive in consideration for any services provided to the firm by B during the period, less amounts of consideration it actually receives, are to be taken to be the notional consideration for services. Now, the services are treated as being provided as if the person weren't a partner and on arm's length terms. So you have to provide for arm's length consideration. But importantly, one has to ask oneself, well, what are services provided to the firm? Now, I think it would be too limited a meaning to that phrase to say it's only consumables that are relevant for these purposes. So provided to the firm isn't simply being a back office provider of admin services or a supplier of just support services. It could just as easily, and what did in Walewski, cover the provision of those services to the LLP such that it can turn them into account in its profit earning activities. But the most important aspect of sub 15 is the limitation placed by sub 17 on it, which is that any services, the provision of which involves any partner in the firm, in addition to B, is ignored for the purposes of subsection 15. So if as was the case in Mr. Walewski's case, the B, i.e. the NRCO, says that it is providing its services that justify the large profit allocation to it by virtue of its provision of services by the appellant to the LLP, the appellant being an employee in that capacity. Therefore, one has to ask, is sub 17 engaged? And obviously it must be engaged because the appellant is also a partner, and B is able to provide its services to the LLP by virtue of using the appellant's services. So therefore, in determining what is the appropriate notional consideration for services for B, one disregards those services that involve the appellant providing those services in his capacity as employee, should that have, in fact have been the case, to the LLP. So then the next question is 3B. So that is the appropriate notional profit is 3A. 3B is, does A have the power to enjoy B's profit share? And he does if he's connected with B, and we've got the definition there, if there are arrangements, the main purpose of which is to ensure that that A's profit share that is included in B's profit share is charged a corporation tax rather than income tax. So it's basically arbitrage that it's looking at. Or any of the enjoyment conditions are met in relation to B's profit share or any part of it. And so what are the power to enjoy? What are the enjoyment conditions? Well, that's all set out for one very conveniently in sub 20. Now, those who are used to transfer of assets provisions will obviously recognize these. The transfer of assets provisions were in fact the crib for these provisions. However, that's where the similarity stops. One can't import in wholesale the analysis that applies to the transfer of assets provisions. So one needs to be aware on a case-by-case basis when one may be able to read across certain meanings. Now, the most important for Mr. Walewski's case was D, because of the structure, if you recall, there was an LLP, there was an NRCO, which was indirectly held by a trust, of which the appellant, who was the settlor's children, were beneficiaries. That clearly comes within D, because A, i.e. the appellant, may become entitled to the beneficial enjoyment of B's profit share or part if one or more powers are exercised or successively exercised by any person. And do keep in mind sub 21, which treats A, any reference to A, as including any person connected with A apart from B. So children of A were clearly connected persons. And then 3C, it is reasonable to suppose that the whole or any part of B's profit share is attributable to A's power to enjoy. Now, the point with this is that if you can show that B has earned what it received, some part of its profit allocation, or in fact all of it, then it is possible to say that it's not reasonable to suppose that any part of that is attributable to A's power to enjoy. But the important point here is that the sub 17 disregard is left out of account, because the sub 17 disregard only applies for the purposes of sub 15. So here you really do have to ask, well, what is it that B is providing? Now, on the facts in this case, there was very little that B was providing. I think its company's house listing was as a holding company. It had no other information about it. It had no other services that it said it was providing. And in fact, it was an entirely, as it were, hollow company, simply there, as it were, to be the NRCO, which would be holding the profits, which would be able to allow the argument to be run. That's my submission anyway. The argument to be run that the provision of services was by the appellant, but in his capacity as employee rather than as partner. Now, so what did the FTT hold in that case? Well, they weren't convinced on the state of the evidence. They said that condition Y of 850C needs to be looked at, as I have looked at it here, in a systematic cumulative way, to see which of these provisions add together to result in an outcome that may or may not result in a reallocation. On the facts, they held that the capital contributions made to the two LLPs were small, and so the return on those was small and well far short of the actual profit allocation. The value of the appellant's services to the main LLP, which was said to be provided by him in his capacity as employee of the NRCO, were low or negligible. And this was the heart of the matter, because if the appellant could have proven that the NRCO provided significant services, then he would have been home free, certainly on consideration as well as on the attribution. But the difficulty was that he didn't keep any timesheets, and he wasn't able to say at any given time whether he was working for main LLP, support LLP, or as an employee of NRCO. Clearly the condition of 3B was met because the children were able to benefit, and 3C was met because there was no other reason given on the facts for why B, the NRCO, would receive such a very large proportion of profits, because it did absolutely nothing, and it wasn't possible on the facts to say that the appellant provided his services qua employee of the NRCO. So what are the learning points here? Well, I think you've pretty much picked them up from the way I've been saying this, which is that if you're going to do it, please do structure it right. and do make sure that the arrangements are consistent with the story that you're seeking to give, which is that if NRCo is going to receive a significant proportion of the profit share, NRCo needs to be able to justify that objectively. Say, for instance, NRCo needs to have the personnel and the capacity to carry out those services. NRCo needs to be the person to which the LLP turns on the basis of its documentations to provide those services. Now, one might say that, well, it's a partner, so why on earth would you need anything more than the partnership agreement? Well, some acknowledgement within the partnership agreement that while the LLP will be making its profit-earning activity outward-facing by seeking clients and provision of services to those clients for a fee, it will be asking for those services to be provided internally by NRCo. And that would go some way, one would have thought, to answer this sort of concern. Also, one needs to be aware of the fact that if the clients really want to engage directly with NRCo rather than with the LLP, that would be interesting. But should they want to do so, then there needs to be a good reason for them to do so, not simply in order to be able to make the argument that it's NRCo providing the services that therefore entitle it to a large proportion of the profit share. One of the reasons might be that somehow it has a capital reserve and therefore is going to be able to support the LLP should the need arise. Or it might be that actually some clients are just not willing or are unfamiliar with the concept of LLPs and would rather be engaging the services of a limited company. But if that is the case, then actually what the clients do is also important, because in order to make that good, there ought to be some interest on the part of the clients when asked to give evidence of what it is that they have done in order to satisfy themselves that the NRCo actually has reserves, if that's the reason that they want to engage with it, or that the NRCo has the capacity to carry out these services. If they haven't even bothered checking any of this, then it becomes really rather difficult to run that argument. Another point also to bear in mind is that when this legislation was introduced in order to deal with cash box companies, i.e. companies that at a low tax cost were holding cash sums for a later distribution at some convenient time. So if that is still the case, then one needs to have a good reason why the company is still holding the cash. So some thought needs to be given for that, because otherwise it would be very easy for the tribunal to say, for instance, that the whole or main purpose of trying to hold cash at corporation tax rates is satisfied. And in terms of time apportionment, it seems that the courts are willing to consider whether or not that this is correct. Is up to the UT to decide on appeal, but it seems that the courts are willing to consider the prospect of some sort of apportionment. If there is to be an apportionment on time terms, then timesheets or other contemporaneous evidence as to who is working for which entity and in what capacity at any given time would be a very good idea. So that's really pretty much as I wanted to say about this case and about Section 850C. I'm now going to hand you over to Rebecca. Rebecca.
So I believe my microphone is on. Can you please nod your head, Aparna, if my microphone is on? Hello? Aparna appears to have frozen, and so has my screen.
We can hear you, Rebecca.
Okay, in which case I am going to share my screen and assume all is fine. Can you all see my slides?
Yes.
Excellent. Okay, so good morning, everybody. I am going to challenge the view which Aparna took in Walewski, which is that a member of an LLP cannot also be an employee, because in my view that construction of Section 4.4 of the LLP Act is wrong. So this is a point which might arise in relation to both pre and post Finance Act 2014 mixed membership LLPs. Then if there's time, I'm not sure there will be, I was briefly going to discuss points which may arise in relation to litigation of pre-Finance Act 2014 mixed member partnerships. So the language of section 4.4 has been acknowledged by many as very difficult, so I've put that up on the first slide. So of course we all know that section 1.2 of the LLP Act provides that an LLP is a body corporate with legal personality separate from that of its members, so members can contract with it. So section 4 provides on the incorporation of an LLP, its members are the persons who subscribe their names to the incorporation document. So provided that your name is on the incorporation document, then regardless of the substance of the individual's relationship with the other members or with the LLP, then they are a member. And subsection 4 goes on to say that a member of an LLP shall not be regarded for any purpose as employed by the LLP unless, if he and the other members were partners in a partnership, he would be regarded for that purpose as employed by the partnership. So the question is, does that preclude a member from being an employee? So in the case of Tiffin and Leicester Aldridge, the Court of Appeal held correctly, in my view, that section 4.4 can't be construed literally because that would lead to absurdity. So this is because, as a matter of English law, a partner in a partnership under the Partnership Act 1980 can't also be an employee of the partnership, as he can't be an employee of himself. So if section 4.4 requires us to assume that the member of the LLP is a partner in the hypothetical partnership, and then to ask whether he would be an employee, it would inevitably follow that he could never be an employee. So that would render the subsection otiose, at least in England and Wales, which, in my view, Parliament should be taken not to have intended. And there's a whole chapter on that in Bennion, chapter 12. And indeed, Lord Hodge recently held in Project Blue that it's without question a legitimate method of proposed statutory construction that one should seek to avoid absurd or unlikely results. Furthermore, section 4.4 appears to recognise that a member of an LLP may also be an employee in certain circumstances. So I don't need to read that out to you because I've just explained it. So Reimer LJ in Tiffin goes on to say what the correct approach to section 4.4 should be, and that is that it should be construed as asking us to assume that the business of the LLP is carried on by two or more of its members as partners in a partnership, and on that assumption to ask whether the person whose status is in question is a partner, and if that's the case, then he can't be an employee. But if the answer is no, he isn't a partner in the hypothetical partnership, then we go on to establish whether he is an employee. And Reimer LJ stresses that after citing the approach of the Employment Tribunal in COVATS, including disagreeing with a part of the Employment Tribunal's approach in that case. So perhaps a shortcut to that question would be just to ask the question, is the individual in substance an employee or a partner in the hypothetical partnership? So the Court of Appeal's construction of section 4.4 in Tiffin was part of the ratio in that case. And so in my view, that's binding on the lower courts at the moment. So how do we answer that hypothetical question? So the Partnership Act 1890 doesn't give us any definition of a partner. Section 1 provides a partnership is the relation which subsists between persons carrying on a business in common with a view to profit. The Court of Appeal held that the primary source material is the members' agreement, but that this will not necessarily represent the totality of what's looked at. And the inquiry requires consideration of the circumstances in which a person may become a partner in a partnership under that Act. So in Steckel and Ellis, McGarry J said that the correct approach is to look at the terms of the relationship to ascertain whether or not it creates a true partnership. And there are, of course, no fixed attributes of the relationship which will make a person a partner. But McGarry J also held that the fact that a person isn't entitled to share in the profits of the partnership will be an indicator, particularly where the person is entitled to receive a fixed sum whether or not the partnership makes a profit. So that's a salaried partner, as we all know it. And in Cobbetts and Hodge, it was held that a partner who is remunerated even where the partnership makes a loss is far more likely to be regarded as an employee. So then the question is, having established that a person is or isn't a partner, if we decide he isn't a partner, we then have to go on and decide whether he is an employee. It doesn't automatically follow that he is an employee just because he isn't a partner. So to do that, we apply the usual case law principles, which I'm sure you're all familiar with. They've been going through the tribunal in various IR35 cases. I recorded a webinar last June on the principles which are being applied by the tribunal in those cases. So that's a link to the webinar. Now, Apurna no doubt argued, I wasn't there, in the case of Walewski, that Tiffin was overruled by the case in the Supreme Court, Clyde & Co. So in that case, Lady Hale referred to Tiffin, and then she said at paragraph 21, but once it's recognised that the 2000 Act is a UK-wide statute, there is no doubt about whether partners in a Scottish partnership can also be employed by the partnership. There's no need to give such a strained construction to section 4.4. All that it's saying is whatever the position would be were the members of the LLP to be partners in a traditional partnership, then that position is the same in an LLP. I would hold, therefore, that that is how section 4.4 is to be construed. So in other words, Lady Hale said that section 4.4 must be construed literally, so that in asking whether a member of the LLP would be an employee of the hypothetical partnership, we have to regard him as a partner. So this inevitably means that in the case of an English LLP, the answer will always be no. But in her view, that didn't matter because section 4.4 can still apply in Scotland. But in my view, paragraph 21 of Clyde & Co. is an obiter dictum. It doesn't necessarily, it didn't form a necessary part of the decision in that case. So the issue in that case, as set out in paragraph 1 of Lady Hale's opinion, is whether a member of an LLP can be a worker within the meaning of section 233 of the Employment Rights Act 1996. So it was argued for the respondent LLP, inter alia, that section 4.4 precludes this, relying on the decision below to the effect that section 4.4 applies to workers as much as it applies to employees. But at paragraph 23 of her opinion, Lady Hale held that employed by in section 4.4 does not cover workers. That being so, it necessarily follows that section 4.4 has no application to workers. So it wasn't necessary to her decision for Lady Hale to hold that the Court of Appeal's construction of section 4.4 in its application to putative employees was incorrect. And it's clear that as a matter of precedent, an obiter dictum of the Supreme Court can't have the effect of overruling a decision of the Court of Appeal. And that is acknowledged by Warren J. in Reinhard, which discusses the tension between these two cases, Tiffin and Clyde & Co. I don't believe I've got time to go through those in detail now. So what I will do briefly is say that in my view, the Tiffin construction is correct, regardless of Hansard, but if we have a look at Hansard, we can see clearly what Parliament's intention was in enacting section 4.4. So the amendment, which is Amendment 12, which inserted the words in subsection 4, is discussed by Lord Mackintosh of Haringey, and he states two issues arise here. The first is where the amendment should be placed in the bill. The noble Baroness rightly identified our wish to have it placed here rather than where it can be seen as an amendment to partnership law more generally. So it's implicit in that section 4.4 is an amendment to partnership law, and indeed it has an effect. And then he goes on the issue of the wording, I only wish it were possible to have a simple definition of an employee. Noble Baroness did not have the misfortune of sitting through as much of the employment relations bill last summer as I did. We spent many happy hours discussing the definition of employee, and I fear this is not the legislation to resolve those questions which could not be resolved at that time. There is not a single test to determine whether or not a person is an employee. Many factors are taken into account. Sharing profits, for example, is prima facie evidence that a person is a partner. If the losses as well as the profits are shared, the presumption is even stronger. But when a person receives both a salary and a share of the profits, there is strong evidence that he is an employee. That was an important consideration when we dealt with the employment relations legislation. There have been requests that any statutory provision should state that members are not employees unless there is an express agreement to the contrary. I believe that is what the noble Baroness is getting at in Amendment number 17. We feel that is going too far. If a person receives a salary, does not share profits, and exhibits all the characteristics of an employee, it's inappropriate for the LLP to exclude the employee's rights in relation to that person. In addition, such an approach would be inconsistent with the employment law approach, under which the description which the parties apply to the relationship, again coming back to Amendment number 17, is not conclusive. And then in relation to the further proposed Amendment 17, which refers back to Amendment 12, it was noted, the third part of the amendment provides that unless otherwise agreed, a member is not an employee of the limited liability partnership. We dealt with that point in Government Amendment 12, which has been agreed, by providing that a member of an LLP shall not be considered an employee simply by virtue of being a member. I hope that at that time I explained why it was we didn't believe this matter should be subject to an agreement with the LLP. It should, in contrast, be part of normal employment law, however opaque that may sometimes be. So, in my view, the debate makes it very clear that the approach in Tiffin is the correct one, so that if somebody is in substance an employee, then he will be an employee of the LLP, notwithstanding that he is also a member. And so just to finish with some quite amusing comments on the language of section 4.4, because it is particularly difficult, we've got Baroness Buscombe stating, notwithstanding that I'm a lawyer, I find it difficult to understand this clause. I've read it more than half a dozen times and wonder whether we can improve the wording, if I may be so blunt. And then Lord Phillips of Sudbury says, I identify myself with the remarks of the noble Baroness, Lady Buscombe. Amendment 12 is work for lawyers, however well intentioned. But I'm not sure whether I could use that as support for the fact that Hansard is admissible, but just on the wording itself, we've got Reimer LJ saying that a literal construction leads to absurdity, which meets the Pepper and Hart criteria for admitting Hansard. But even without Hansard, in my view, the Tiffin construction is the correct one. I think that leaves me no time at all to deal with the issues. So just to mention instances where that point may be relevant. So pre-Finance Act 2014 avoidance arrangements. So there were NIC avoidance arrangements, for example. So if you had a partnership which incorporated, then it could make its salaried partners members of an LLP in the hope that Clyde & Co would be the correct construction so that you could avoid NIC in that way. but it may also be relevant to post-Finance Act 2014 arrangements, as Walewski shows us. I'm afraid I can't see what the time is. Do I have a couple of minutes just to discuss these points? Everybody seems to be on mute. I'll just spend a couple of minutes on this slide. So just to briefly discuss some of the points which are going through the tribunals at the moment in relation to pre-Finance Act 2014 mixed member partnerships. So this is the current version of Section 850, but the relevant part of it is the same in relation to pre-Finance Act 2014 mixed member partnerships. So in terms of ascertaining the allocation of the firm's profits and losses between partners, we see in subsection 2, in this section, profit sharing arrangements means the rights of the partners to share in the profits of the trade, the liability of the partners to share in the losses of the trade. So points which are going through litigation at the moment is the construction of profit sharing arrangements, and in particular whether the Ramsey principle is applicable to the notion of rights in that section. And also relevant may be the application of the sales of occupation income provisions. So they won't apply if the individual's activity in the partnership are a trade. So questions about whether there is a trade or a professional vocation are arising. So I think I've gone way over time, so sorry about that. I'm going to hand back now to the panel.